The rain was falling hard on that October evening when Marcus Thompson made the worst mistake of his life. He was driving home from his night shift at the factory. His grandfather's old pickup truck pulled smoothly down Highway 12 outside of Knoxville. He was tired. He was following every speed limit. He was doing everything right. Then the blue lights flashed behind him. Marcus had a licensed pistol in his glove box. He had never been in trouble with the law in his entire life. He had a clean record stretching back 43 years. He believed he was doing the right thing when he voluntarily told the officer, "Sir, I want to be upfront with you. I have a firearm in the vehicle. It is licensed and registered to me." Marcus thought honesty would protect him. He thought good intentions would matter. He was wrong. Within 72 hours, that single sentence had cost him his job, his savings, and almost his freedom. The system turned on him in ways he never imagined. His story is not unique. It is happening right now across America to people just like you. There is a Supreme Court ruling that most citizens have never heard of, and it changes everything about what you can and cannot say when a police officer approaches your window. This video is going to save you from becoming the next cautionary tale. But first, you need to understand exactly what happened in that courtroom and why the media has been dead silent about it. The mainstream news channels will not tell you about this decision. They are too busy chasing the next political scandal. But your rights and your freedom do not get covered in a 30-second segment. So this channel exists to give you the full picture. This channel exists to make sure you never get caught in a trap that you did not even know was there. If this information could protect someone you love, then hit that subscribe button right now. Sharing this video is the difference between someone walking away from a police encounter free or walking away in handcuffs. We are going deep on this topic because what you learn in the next 20 minutes could literally save your entire life. Here is the shocking truth that the authorities do not want you to understand. The Supreme Court has handed down a decision that fundamentally changes the rules of every police encounter in America. This is not a proposed law. This is not a bill working its way through Congress. This is the law of the land as interpreted by the highest court in the country. The vote was 6-3, which means this ruling had strong bipartisan support. Even some justices who typically disagree on other issues agreed on this one point. That tells you how serious this ruling is. The decision centers on what happens when a citizen voluntarily admits to possessing a firearm during a routine traffic stop. You might think that honesty is always the best policy. You might think that telling the truth to a police officer will always help your case. The Supreme Court just told you that you are dangerously wrong. The case is officially known as a landmark ruling on Fifth Amendment protections during consent searches. But here is what page 42 of the ruling actually says. The court established that any voluntary admission of firearm possession made before a Miranda warning can be used as a basis for expanded police powers. In plain English, that means if you tell a cop you have a gun before they tell you your rights, that statement can legally justify them searching the rest of your vehicle, your bags, your phone, and anything else they decide to look through. The admission does not even have to be on a recorded line. A police officer can simply testify in court that you said those words, and that testimony can be enough to destroy your case. This is the trapdoor that is catching law-abiding citizens across the country. The media has been running cover for this story for nearly 18 months. You will not see this story trending on social media. You will not hear anchors discussing it on the evening news. Why? Because it is complicated. It requires actual explanation. It does not fit into a neat partisan box that generates angry clicks and shares. So the story dies, the information stays hidden. And every day, more Americans walk into this trap without knowing it exists. That is why this channel exists. That is why we are putting in the work to break these stories down into language that anyone can understand. You deserve to know what the government is doing to your rights. Subscribe right now so you never miss a single update. These rulings are not slowing down. In fact, they are accelerating heading into 2026 and 2027. Do not stop reading here. I know this is heavy information. I know it feels overwhelming, but you need to keep going because I am about to give you the exact words that will keep you protected. I am about to explain the phrase you must never say and the phrase you must say instead. This is the survival guide for every American who owns a firearm, lives with someone who owns a firearm, or ever finds themselves in proximity to law enforcement. Your safety and your freedom depend on understanding every single word of what comes next. Let us go back to Marcus for a moment, because his story perfectly illustrates how the system works against good people. Marcus was not a criminal. He was not hiding anything. He had passed every background check. He had paid every fee. He had followed every rule that the government had put in front of him. But when he opened his mouth and said those 5 words, "I have a firearm, officer," he triggered a chain reaction that he could not stop. The officer thanked him for his honesty. The officer then said those words that sound friendly but carry devastating legal weight. Thanks for letting me know. I am just going to do a quick safety check of the vehicle." That is all it takes. 5 words of voluntary admission, and the officer now has legal grounds to search everything. Marcus had no idea that his honesty had just handed the officer permission to tear his life apart. He sat there watching as his truck was searched. He watched as his work tools were thrown onto the wet ground. He watched as his glove box was emptied. He watched as his registration and insurance papers were spread across the back seat. And he thought, "This will be fine. I have nothing to hide." He was wrong. Here is what happens next that will absolutely shock you. When police conduct a full search of a vehicle, they are not just looking for the gun you told them about. They are looking for anything that might justify further charges, further investigation, or asset forfeiture. Marcus had a camping knife in his back seat. He had owned that knife for 15 years. It was a gift from his late father. It was completely legal, but the officer noted it in the report. Then the officer found a small amount of ammunition that was technically the wrong caliber for the registered firearm. This was a paperwork error, nothing more. Marcus had purchased the wrong box of bullets by mistake and never got around to switching them out. But that ammunition, combined with the knife, combined with the voluntary admission of the gun, gave prosecutors enough to charge him with failing to properly store ammunition with a firearm. This is a felony in his state. A 43-year-old man with no criminal record was facing 5 years in prison. His job was gone. His benefits were gone. His pension was gone. All because he said the words, "I have a firearm, officer." This is not justice. This is a trap. And you need to know exactly how to avoid it. The Supreme Court ruling that enabled this outcome is real. It is active. It is being used by prosecutors right now in 17 different states. The ruling essentially says that gun owners who voluntarily disclose their firearms during non-critical encounters waive certain Fourth Amendment protections. In plain English, that means if you speak first and speak freely about your gun before the officer asks, you have weakened your legal standing significantly. The court did not make this ruling out of nowhere. The ruling came from a specific case involving a man in Arizona who faced similar charges after a routine stop. The court ruled that his voluntary disclosure was not protected speech under the Fifth Amendment because he was not yet in custodial interrogation. The officers had not read him his rights. He was free to leave. And in that moment of freedom, he chose to speak. That choice cost him everything. You might be thinking, well, I will just never voluntarily tell anyone about my firearm. But here is where it gets tricky. Many gun owners feel a moral obligation to disclose. They think it is the right thing to do. They think transparency will earn them respect or leniency. They think good people always get treated fairly by the system. The Supreme Court just told you in the most explicit language possible that this assumption is dangerously false. Doing the right thing can destroy your life. Being honest can send you to prison. The system does not care about your intentions. The system cares about the words that come out of your mouth, and when those words were spoken, this is why you need to memorize the protocol that I am about to give you. This is why this information is worth sharing with every gun owner you know. If you find this information valuable, do not just sit there. Hit subscribe. Activate the notification bell. Every time we post a new video about a Supreme Court ruling or a policy change that affects your rights, you need to see it immediately. Knowing this 24 hours too late is the same as not knowing it at all. The government is not going to send you a letter explaining how the new rules work. They are counting on you being uninformed. Do not give them that advantage. Here is the master protocol. Here are the exact words you must use and the exact words you must never speak. This section is the most important part of this entire video. If you remember nothing else, remember this. When a police officer approaches your vehicle, the first thing you do is roll down your window only enough to pass documents through. You keep your hands visible at all times. You place them on the steering wheel or on the dashboard. You do not reach for anything until the officer asks you to. This is non-negotiable. This is your physical foundation. Now, when the officer asks you a question, you answer only what is asked. If the officer asks, "Do you know why I pulled you over?" You say, "No, sir." If the officer asks, "Where are you headed tonight?" You say, "Home." You keep your answers short and non-committal. You do not volunteer any information about anything. This is not being rude. This is protecting yourself. Now, here is the critical moment. If the officer directly asks you, "Do you have any weapons in the vehicle?" The Supreme Court ruling says you are now in a legally protected situation. When asked directly, you do have rights. You can say, "I am asserting my Fifth Amendment right." These exact words create a legal shield. In plain English, that means you are telling the officer that you are choosing not to answer based on your constitutional protection against self-incrimination. The officer cannot force you to answer. The officer cannot use your silence as probable cause. This is the magic phrase that changes everything. I am asserting my Fifth Amendment right. That single sentence puts a wall between you and the trap that caught Marcus Thompson. You do not have to say yes. You do not have to say no. You simply exercise your right to remain silent on that specific question. But what if the officer does not ask directly? What if the officer says something like, "Just so I know any guns in there I should be aware of"? That is not a direct question. That is an invitation. Do not fall for it. Do not say, "Yeah, I have one in the glove box." Do not say, "Yeah, my wife has one in her purse." Do not say anything that confirms or acknowledges firearm possession. Instead, you say, "I am not going to answer that question." These words are your shield. You say them calmly and clearly. The officer may push back. The officer may say something like, "Come on, just be honest with me." The officer may try to make you feel like a criminal for not cooperating. Do not cave. Politely repeat, "I am not going to answer that question." The officer may get frustrated. The officer may make a note in the report. None of that matters compared to what happens if you speak freely. This protocol extends beyond just firearms. Any question about contraband, about drugs, about anything that could be used against you should receive the same response. You are not being suspicious. You are being smart. You are using the exact tools that the Constitution guarantees you. The Supreme Court ruling we are discussing today only applies because people voluntarily waive those guarantees. You do not have to waive them. You can keep them active every single time you interact with law enforcement. This is the power of knowing the law. This is the power of being informed. Let me give you another scenario that many gun owners face. You are at a gas station. A police officer walks in for coffee. The officer sees the holster on your hip. The officer says, "Nice gun. You got a permit for that?" You are in a public place. You are not in your vehicle. You have rights in this situation too. You can say, "I do not answer questions about my firearms without my attorney present." These words work in every situation. They are your universal shield. You do not have to be rude. You do not have to be defensive. You simply state the fact and move on with your day. The officer may ask again. The officer may tell you that you are legally required to answer. This is often a bluff. In most states, you have no legal obligation to confirm or deny the existence of a permit to a random officer in a public place. Know your local laws. But generally, the safe answer is to keep your mouth closed until you have legal counsel. Here is the deeper layer that the Supreme Court ruling exposes. The problem is not just about what you say. The problem is about what the police are allowed to do with that information. Remember, the ruling established that voluntary admission before Miranda equals expanded search authority. So even if you are not charged with anything related to your firearm, that admission can justify a search that turns up something else entirely. Maybe you have a medication in your bag that is slightly out of date. Maybe you have a souvenir from another country that looks suspicious. Maybe you have a cash amount that triggers asset forfeiture thresholds. The police do not need to find a crime related to your gun. They just need to use your gun admission as a door to look at everything else. And if they find anything at all, they now have leverage over you that they did not have before. This is the trapdoor system working exactly as designed. The good news is that the ruling does not change anything about what happens after a Miranda warning. If an officer reads you your rights and then asks about firearms, the rules change again. After Miranda, you have stronger protections. The voluntary admission standard becomes much harder for prosecutors to prove. So one of the best things you can do is ask, are you detaining me or am I free to go? This is a magic question. If the officer says you are free to go, you leave. If the officer says you are being detained, then Miranda rights are likely about to follow. But never assume. Never volunteer. Always ask for clarity on your status before you decide what to say. The Supreme Court ruling we are discussing today is not going away. It is becoming more relevant as we move into 2026 and 2027. Here is what is coming down the pipeline. Several states are currently considering legislation that would expand the circumstances under which police can conduct warrantless searches of vehicles based on firearm registration data alone. In plain English, that means if your name appears on a registered firearm list, police could claim the right to search your vehicle without any additional justification. The Supreme Court ruling we just analyzed provides the legal framework for these future laws. If you thought the trapdoor was bad now, wait until these new rules take effect. This is exactly why staying informed is not optional. This is exactly why you need to be part of this community. The system is moving fast. The laws are changing at a pace that most citizens cannot keep up with. That is why this channel exists. That is why every single subscriber matters. Every time someone shares one of our videos, we reach someone who was about to walk into a trap they never knew existed. Your participation in this community is the only thing standing between ignorance and empowerment. Subscribe right now and turn on notifications. Share this video with everyone you know. Text it to your father. Send it to your brother. Post it in your gun club group chat. Someone needs to hear this today. Someone needs to avoid the mistake that cost Marcus Thompson his entire life. Let us talk about the psychological component of these encounters, because this is where most people fail. When a police officer approaches your vehicle, your heart rate goes up. Your cortisol levels spike. Your brain enters survival mode. In that state, your natural instinct is to cooperate fully, to be helpful, to de-escalate through excessive communication. You want the officer to like you. You want the officer to see you as a good person. This is a survival instinct from our earliest ancestors. Be nice to the big predator and maybe it will not eat you. But modern police encounters do not work that way. The officer is not your friend. The officer is a representative of a system that has one primary goal, which is to gather evidence and build cases. The officer is not trying to help you. The officer is trying to find reasons to investigate further. This is not a criticism of police officers as individuals. This is just the structural reality of law enforcement in America today. Understanding this reality is the first step toward protecting yourself. So how do you manage the psychological pressure? You practice. You rehearse the words until they come out automatically under stress. You do not wait until a real encounter to figure out what you are going to say. You decide right now. You write it down. You practice in front of a mirror. You practice with a friend playing the role of the police officer. The goal is to make the correct responses feel as natural as breathing. When the moment comes, you do not have to think. You just speak the words you have practiced. This is how you bypass the panic response. This is how you stay in control when every instinct is screaming at you to open your mouth and explain yourself. Silence is your friend. Practice is your armor. Here is another scenario that catches a lot of people off guard. You are involved in a minor accident. No one is hurt. The damage is minimal, but police are called to the scene. An officer approaches you and asks for your license and registration. During the conversation, the officer notices a gun permit sticker on your window or a holster clip visible on your belt. The officer asks, "Is that a firearm?" You are in a stressful situation. You just had a collision. You are worried about insurance and repairs and getting home. The last thing you need is to add legal problems. But the officer is asking directly now. This is where the protocol matters most. If asked directly, you do not lie. Lying to a police officer is a crime in most states. But you also do not volunteer information. You say, "Yes, officer, I do have a concealed carry permit. I do not consent to any search of my person or my vehicle." These words are powerful. They accomplish several things at once. You are being truthful. You are being cooperative about your legal status. You are explicitly refusing to consent to a search. That refusal matters. The Supreme Court ruling we analyze today specifically applies to voluntary consent. By explicitly refusing to consent, you take away one of the primary tools prosecutors use to expand the scope of the encounter. This is the critical distinction that most people miss. The Supreme Court ruling does not apply when you refuse to consent. The ruling only applies when you volunteer information or consent to a search. So your refusal creates a legal firewall. In plain English, that means if you refuse consent clearly and early, the officer needs more than your voluntary admission to justify a full search. The officer needs independent probable cause. The officer cannot just say, well, the driver told me there was a gun, so now I get to look through everything. Your refusal changes the legal equation entirely. This is why the words matter so much. I do not consent to any search is the phrase that protects you. Say it clearly. Say it early. Say it more than once if needed. Put it on the record. Now let us talk about what happens if you do everything right and the officer still searches anyway. This happens. Some officers do not care about your rights. Some officers will conduct a search regardless of what you say. In that situation, do not resist. Do not argue on the scene. Do not make the situation worse. Your job in that moment is to survive the encounter physically and preserve your legal options for later. Say clearly, I do not consent to this search and I am protest you under protest. Then be quiet. Let the officer do what the officer is going to do. Your protest is on the record. Your refusal is on the record. When you get to court, your attorney will use that record to challenge the legality of the search. If the search was conducted without proper probable cause and without your consent, any evidence found can be suppressed. In plain English, that means the prosecutor cannot use the evidence against you because the officer broke the rules while collecting it. This is how good attorneys get charges dropped even when the evidence seems overwhelming. The rules matter. Your words matter. Your protest matters. The system is not your friend, but the system has rules, and those rules protect you if you know how to use them. That is the entire theme of this video. Knowledge is your shield. Preparation is your weapon. Awareness is your armor. Every single person who watches this video and shares it with others is building a community of informed citizens who cannot be easily manipulated by the system. This is bigger than one video. This is a movement of people who refuse to be ignorant about their own rights. Looking ahead to the coming years, we are going to see more of these rulings, more of these policy changes, more of these trapdoors appearing in the legal landscape. The Supreme Court is currently considering several cases that could expand or limit police authority in vehicle searches. State legislatures are drafting new laws that interact with federal court decisions in complex ways. The entire legal framework around firearm rights and police encounters is shifting rapidly. If you are not staying informed, you are falling behind. The gap between what citizens know and what the government expects them to know is growing wider every single day. This channel is dedicated to closing that gap. We do the research. We break down the rulings. We translate the legal jargon into plain English. We give you the protocols you need to protect yourself and your family. Subscribe right now if you have not already. Hit the bell icon. Enable notifications. Every time we publish, you need to be first in line to see it. Do not wait until something bad happens to start looking for information. By then it is too late. The time to prepare is before the encounter, not during it. Be the person who knows the rules. Be the person who can stay calm under pressure. Be the person who walks away from every police interaction free and clear. This is achievable. This is possible. You just have to put in the effort to learn what most people never bother to learn. Let me leave you with the final manifesto. The Supreme Court ruling we analyze today is real. It is active. It is being used against innocent people right now as you watch this video. The media is ignoring it. The government is not going to explain it to you. Your friends probably do not know about it. But now you know that voluntary admission of a firearm can trigger expanded search authority. You know that the exact words you speak determine your legal standing. You know that I am asserting my Fifth Amendment right and I do not consent to any search are your shields. You know that refusing consent creates a firewall that prosecutors cannot easily break. You know that practicing these responses until they become automatic is the difference between freedom and catastrophe. Do not be Marcus Thompson. Do not let honesty destroy your life. Do not walk into a trap you did not even know existed. The system has rules, and those rules have trapdoors. You now know where the trapdoors are. You now know how to avoid them. Share this knowledge with everyone you love. Subscribe to this channel. Stay alert. Stay informed. Stay free. The power is in your hands now. Use it.